his life on the line. Good morning, Your Honors. If it please the court, obviously, since my client is sentenced to death, the resolution of this case is of paramount importance to him. But the interests at stake here are far broader, and that is because we are dealing with pure questions of law about the interpretation of what I'll call the DNA statute.
What is the meaning of this Arkansas statute? There's language in that statute that says that if the DNA evidence excludes the defendant as the source of the DNA, which it did in our case, then the trial court has to consider all the evidence, whether it was admitted at trial or not, to see what a reasonable juror would do today.
This statute was passed to exonerate the innocent. The state has really proposed an Orwellian interpretation of the term all. All simply means all.
The state took the position that in weighing all the evidence, what the statute meant to say was that the court consider only all the evidence of guilt, but not the evidence of innocence, which is nonsensical. Because, of course, if a trial court were to look at the DNA evidence but then only consider all the evidence of guilt, the court wouldn't be considering everything that makes a compelling case for innocence.
Let me ask you a question, Mr. Riordan. Let's focus on the evidence situation, and let's say that I agree with you that maybe the trial judge was in error with respect to just limiting the evidence to evidence of guilt. What evidence then would be considered? Would it be the evidence that was presented at the trial or everything that's occurred over the last 17 years?
I don't think that it can be rationally read other than to say the court must consider that is place in the scale not only the evidence of guilt, but also all other evidence, whether or not admitted at the first trial.
Court will recognize counsel for appellate.
Good morning. May it please the court. Mr. Echols has been to this court several times in the last decade, challenging his conviction directly and collaterally. And this statute does not call for a retrial. It's not about trying somebody again for the state to prove guilt twice.
Counselor, what harm is there in allowing him to present the evidence from the last 17 years?
I'm sorry.
What harm is there in allowing him to present all evidence?
Well, the harm is in the finality of a criminal judgment that is not demonstrated to have any constitutional or procedural defect, and just to try it again. I mean, you're suggesting, it sounds to me, Justice Priebe, as though every 15 or 17 years or so we really ought to try cases again to reestablish guilt. I think it's clear that the animating purpose here is not to retry. So the harm is to the criminal justice system's interest in finality and the work that gets done in evaluating whether or not justice has been served in each of the forums that Mr. Echols has been through already.
It sounds as if your argument is that all evidence of guilt will be considered, but it's going to be extremely difficult to admit all other evidence that may have been exculpatory.
I think that is the argument. It's the second alternative reason the circuit court concluded that relief should be denied. And to me, that's a reasonable statute.
But where does it say all other evidence of guilt?
I understand that it doesn't expressly say that, but you have to interpret the statute in light of its animating purpose, and you have to interpret it in light of rules of grammar. I mean, I think that's a very fair construction.
I'm having trouble following you. If the testing has to prove you're innocent, why would you even need a hearing?
Well, again, I think you have to go back to context, Your Honor.
We have to deal with the clear meaning of the statute. I understand your context argument, but we still have to deal with the clear language of the statute.
It comes out of a mindset that says our job as prosecutors is just to make sure that everybody we prosecute is convicted, everybody who's sentenced to death is killed. This is a wrestling match and to the death, and we've got to make sure that we come out on top in each instance. The legislature, in its wisdom, recognized that the criminal justice system, like all human endeavors, sometimes is flawed. But the Attorney General has taken the position that the criminal justice system is free of error and therefore is effectively divine. I quote from their brief in the circuit court, "The state does not shrink from Echols' charge that relief may never be granted under this view of the statute," its view, "but embraces it out of confidence that the Arkansas criminal justice system does not convict the innocent." The state has taken a position that's directed not only about denying relief to Mr. Echols, Mr. Baldwin, Mr. Miskelly, but ensuring that no one will ever be able to get relief under the Arkansas DNA statutes.
Riordan, your time has expired.
I thank the court for its attention and recognize the court may feel that the appropriate remedy is a remand to the trial court for an evidentiary hearing. Thank you, Your Honor.
Thank you very much.